course, the Artificial Intelligence Act has only come into force recently. But the question tackled by the Artificial Intelligence Act, which concerns automated analysis, has been tackled by the Court of Justice since years. For instance, there was a case in 2008 when the Commission made an infringement procedure against Spain because Spain was refusing the entry into its territory to third country nationals only based on an alert given by Germany in the Schengen information system. And already in this case, we said that this automatic consequences could not be accepted when they are not controlled by necessarily a court, and therefore Spain was condemned by this infringement procedure. A very important case law is that of 2014, Digital Rights and Zeitlinger, where we annulled the data retention directive, above all because member states could collect all sorts of information about you, metadata, of course, not going beyond, but only metadata. But this metadata could give, by automated analysis, by automated processing, give the member states a whole view of your private life, and therefore we found out that it was against this, was not compatible with the Charter of Fundamental Rights. Of course, we had some other very important case law since then. For instance, the PNR case law is called Ligue des droits humains, where we said what in a PNR text collecting the data of passenger could be rightful or could really endanger the private life by automatically processing. And therefore, one very important sentence we wrote not only in this PNR decision is that you should never rely only on automated processing. All automatic processing should be verified by human intervention. The human being is over the automatic procedure. And that sentence comes out in all our decisions. And the last one, very recent, is the German Schufa case, where a credit agency collected informations about all sorts of persons to find out whether they are creditworthy. And these informations were given to, of course, a third party, for instance, a bank. And these banks normally accept totally what the scoring of Schufa said, and then they said, you can get no loan for us because the Schufa scoring is against you. So the question was, who takes the decision, Schufa or the third party, the bank? And we said the decision is Schufa, because only the Schufa can be attacked by the persons concerned, and they must have an effective review, and they must get information, meaningful information about how this scoring functions. So you see, even before we have to deal with the new Artificial Intelligence Act, the Court of Justice has had to tackle with a lot of these questions, and we always tried to protect the fundamental rights.